There are no facts to dispute before this court. I see no evidence that has the needed personal subject matter jurisdiction. The state is a fictitious plaintiff. The state of isn't here to testify. No injured man or woman is present before this court to provide firsthand knowledge. I am acting as surety for the named principal to contest jurisdiction. I am aware this is a taxable event and an excise tax is owed, and I want to be in compliance with the IRS code.
Probation will be a waste of time in this matter, so I will revoke and remand you to serve your sentence, take her into custody.
All right. $1,200 every minute I'm in jail.
All right, folks, buckle up for this one, because what we've got today is another sovereign citizen disaster, and it is every bit as messy as you'd expect. Now, here's the situation. This woman is in court for violating probation. The violation? Drug use. Meth, to be exact. But instead of doing the one smart thing, working with her public defender, she decides, nope, I've got this. She fires her lawyer on the spot and announces she's going to represent herself. Because, of course she does, and right away you can feel—
Your Honor, this comes before the court today on a probation violation hearing. And it's the intent of the defendant at this time to stipulate. And I do believe there's a agreed sentence, as you would say in this case.
All right. Ms. Clark, you've heard the announcement of your attorney. Is that what you want to do? Admit to the violations?
No, actually, I'm going to make a motion for my attorney to withdraw. I got this myself.
Oh, okay. What's the reason for that?
I just want to represent myself.
Okay. All right. Well, somebody give her a waiver of attorney form. Okay. It's muted for some reason. All right. Well, I've already gone over these rights with you, so you should understand them, but you have the right to hire your own attorney. If you can't afford to hire an attorney, I've already appointed one, you qualified. You do have the right to represent yourself as well, and that's what you want to do today?
Yes, sir.
All right. If you want to waive your right to an attorney, when we do this, you have to follow the rules of procedure and evidence, just as if you're an attorney. You understand that?
Yes, sir.
All right. Has anyone promised you anything or threatened with anything to get you to waive your right to an attorney?
No, sir.
All right. Looks like you've already signed it and sent it in here. Did you understand this form you signed?
Yes, sir.
I'll accept your waiver and allow you to represent yourself. All right. Are you wanting to stipulate to the violations, or do you want to contest the hearing?
I'm going to contest it.
All right. Mr. Hollis here.
Yes, Judge, I can grab them real quick.
Okay. Okay, state has the burden. Any opening statement, Mr. Marcinski?
No, sir. Thank you.
All right, Ms. Clark, any opening statement?
No.
where this is going. The judge gives her all the warnings. You understand you'll be held to the same standards as an attorney? You'll have to follow court procedure? And she just nods along like it's nothing. Folks, this is like trying to fly a plane after watching a 5-minute YouTube tutorial. When the state lays out its case, it's straightforward. She tested positive for meth, she skipped probation meetings, she didn't report new criminal charges, and she flat out ignored treatment. Requirements. The probation officer gets up, testifies point by point, and honestly, it's airtight. Then it's her turn. And what does she do? Nothing. No questions for the witness, no evidence, no defense. She just—
All right. State may call this first witness.
Thank you, sir. The state would call Court Service Officer Christopher Hollis. Sir, will you please state your name for the record?
Chris Hollis. I'm a court services officer.
In that job occupation, were you assigned the supervision of a Miss Ashley Clark? That supervision being for an endangering a child underlying 12-month sentence?
That is correct.
On May 18th of this year, 2023, did you test Miss Clark for the presence of drugs?
Yes,
And what was the result of that UA sample from Miss Clark?
it was positive for methamphetamine.
So her
stating that
UA
she-
was positive for methamphetamines, and she also, in response to that positive UA test, signed in a statement of admission of using methamphetamines.
That's correct.
Did you order her to report on June 2nd, 2023?
I did.
And did she appear on that day?
She did not.
Has she appeared or reported to you since that time?
No.
Sometime after May 24th of 2023, were you advised by local authorities of her being arrested for a new crime?
Yes, and I did. I received that, and apparently she has new charges.
To your knowledge or to the notes, did Ms. Clark ever report that negative law enforcement contact with your office?
No, she did not.
That will be my questions for Mr. Hollis at this time, Your Honor. Thank you.
All right, Ms. Clark, do you have any questions for Mr. Hollis?
No,
All right, do you have any further evidence or witnesses, Mr. Marcinski?
Not at this time, Your Honor. I do not.
All right, Ms. Clark, you have time to, now it's your turn to present any evidence if you want to. Do you wish to present any evidence?
right now I see no evidence. This has the needed personal subject matter jurisdiction.
If you want to present any evidence, do you want to present any evidence?
Sits there like she's waiting for the universe to bail her out. It's brutal to watch. And when the judge asks if she wants to make an opening statement, she says, no. That was her shot, her one chance to tell her side, to at least try and sound like she had a plan. Instead, she throws it away. At this point, I almost felt a little sympathy. Watching her sink in real time, you start thinking, man, she really doesn't know what she's gotten herself into. But then she opens her mouth at closing arguments. And let me tell you, folks, it goes from sad to absolutely ridiculous in the blink of an eye. Because this is where she finally unleashes the classic sovereign citizen script. So here we are.
No? Okay. Well then, closing argument, Mr. Marcinski?
Your Honor, at this time, the state believes it is shown by a preponderance of the evidence that Ms. Clark is in violation of her probation and conditions of probation imposed by the court therein. The state's going to ask that you find that she is in violation of that probation. The state would point out that this is a misdemeanor probation for endangering a child. Therefore, Ms. Clark is entitled to no graduated sanctions, intermediate sanctions, or other relief set forth by the legislature on felony probations. Due to the litany of violations, the continued drug use, the failure to follow through with her treatment requirements, the state believes that she's shown that she's not amenable to probation and would recommend the court revoke and remand her to serve her underlying sentence.
All right, Ms. Clark, closing argument?
There are no facts to dispute before this court. I see no evidence that has the needed personal subject matter jurisdiction. The state is a fictitious plaintiff. The state of isn't here to testify. No injured man or woman is present before this court to provide firsthand knowledge. I am acting as surety for the named principal to contest jurisdiction. I am aware this is a taxable event and an excise tax is owed, and I want to be in compliance with the IRS code.
Okay. It'll be the order and judgment of this court. Well, first of all, I'll make my findings. The state's shown by preponderance of the evidence that you violated probation in this case using methamphetamine around the 18th, as evidenced by the 18th of May this year, as evidenced by the positive UA and the admission. Also find that you failed to report in violation of probation as alleged. That would be the June 2nd, 2023 date. You failed to successfully complete outpatient treatment at Summer Mental Health as ordered by the court, so I find you violated probation there as well. You also failed to report law enforcement contact within the business day in violation of the orders of probation. You have violated, it does in a very substantial way. I will go ahead. It appears as if probation will be a waste of time in this matter, so I will revoke and remand you to serve her sentence, take her into custody.
All right. $1,200 every minute I'm in jail.
Are at the finish line, And instead of even pretending to address the evidence, she decides this is her moment to lecture the judge about jurisdiction and her so-called sovereign rights. You know the type. Suddenly she's an expert in constitutional law because she spent a night on Facebook University. She starts rambling about how she's a free woman of the land, how the court has no authority over her, and that these laws don't apply. Folks, this isn't a legal defense. It's a comedy routine. The judge is just sitting there staring, probably thinking, why do I even bother? The state doesn't even need to push back. The probation report, the dirty drug test, the skipped meetings, it's all sitting there in black and white. She has nothing to fight it with, except this recycled pseudo-legal nonsense that never works. And here's the best part. The judge lets her talk, lets her go on and on, digging that hole deeper and deeper. Then, with the calm of a man who's heard this circus act 1,000 times before, he drops the verdict. Probation revoked. Jail time imposed. Boom. Just like that, her little sovereign citizen experiment blows up in her face. She thought she was outsmarting the system by firing her lawyer and playing legal genius. Instead, she walked straight into the buzzsaw and lost everything. And the moral here? Court isn't a game. You can't charm your way out of hard evidence with fake legal jargon. The system doesn't care about your YouTube law dictionary. It cares about facts, compliance, and reality. This wasn't just a loss. It was a self-inflicted crash landing.